5 seconds to go. Start. The Constitution of India confers under Article 19(1)(a) the right to freedom of speech and expression to all its citizens. The state has a correlative duty to abstain from interference with such right except as provided in Article 19(2) of the Constitution, which are reasonable restrictions on the right conferred under Article 19(1)(a). The extent of such duty depends upon the content of speech. For instance, in respect of speech that is likely to be adverse to the interests of sovereignty and integrity of India, the security of the state, friendly relations with foreign states, public order, decency or morality, or speech that constitutes contempt of court, defamation, or is of such nature as would be likely to incite the commission of an offence, the duty of the state to abstain from interference is nil. This principle is constitutionally reflected under Article 19(2), which enables the state to enact law which would impose reasonable restrictions on such speech as described under the 8 grounds listed herein above, which are the basis for reasonable restrictions. Per contra, in respect of speech and expression, which constitutes an exchange of ideas, including dissent or disagreement, and such ideas are expressed in a manner compatible with the ethos cultivated in a civilized society, the duty of the state to abstain from interference is high. Similarly, in respect of commercial speech, the state is completely free to recall or curb commercial speech which is false, misleading, unfair, or deceptive. Therefore, the threshold of tolerance towards commercial speech or advertisements depends on the content of such speech and the object of the material sought to be propagated, circulated. The duty of the state to abstain from interference would also depend upon the nature and effect of the commercial speech. As is evident from the above illustrations, the extent of protection of speech would depend on whether such speech would constitute a propagation of ideas or would have any social value. If the answer to the said question is in the affirmative, such speech would be protected under Article 19(1)(a). If the answer is in the negative, such speech would not be protected under Article 19(1)(a). In respect of speech that does not form the content of Article 19(1)(a), the state has no duty to abstain from interference having regard to Article 19(2) of the Constitution and only the grounds mentioned therein. Having noted that the protective perimeter within which a person can exercise his or her rights depends on the degree to which the state is duty bound to protect the right, it may also be said as a corollary that in respect of speech that does not form the content of Article 19(1)(a), the state has no duty to abstain from interference, and therefore speech such as hate speech, defamatory speech, etc., would lie outside the protective perimeter within which a person can exercise his right to freedom of speech. Such speech can be subjected to restrictions or restraints. While restrictions on the right to freedom of speech and expression are required to be made only under the grounds listed under Article 19(2) by the state, restraints on the said right do not gather their strength from Article 19(2). Restraints on the right to freedom of speech and expression are governed by the content of Article 19(1)(a) itself, that is, any kind of speech which does not conform to the content of the right under Article 19(1)(a) may be restrained. Questions pertaining to the voluntary or binding nature of such restraint, the force behind the same, the persons on whom such restraints are to be imposed, the manner in which compliance thereof could be achieved, etc., are aspects left to be deliberated upon and answered by the Parliament. However, the finding made herein above is only to the extent of clarifying that any kind of speech which does not form the content of Article 19(1)(a) may be restrained. As such, speech does not constitute an exchange of ideas in a manner compatible with the ethos cultivated in a civilized society. Such restraints need not be traceable only to Article 19.2, which exhaustively lists 8 grounds on which restrictions may be imposed on the right to freedom of speech and expression by the state. The freedom of speech and expression under Article 19(1)(a) is a right with diverse facets both with regard to the content of speech and expression and the medium through which communication takes place. It is also a dynamic concept that has evolved with time and advances in technology. In short, Article 19(1)(a) covers the right to express oneself by word of mouth, through writing, pictorial form, graphics, or in any other manner. It includes the freedom of communication and the right to propagate or publish one's views and opinions. The communication of ideas may be through any medium, such as a book, newspaper, magazine, or movie, including electronic and audio-visual media. Freedom of the press takes within its fold a number of rights, and one such right is the freedom of publication. Publication also means dissemination and circulation. Indeed, without circulation, publication would be of little value. White, Romesh Thapad, Sakal Papers Private Limited versus Union of India, AIR 1962 SC 305. Stop.